90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to learn about the world of bankruptcy after COVID, and our special guest is Andy Thaler. He's the head of a boutique bankruptcy firm. He also acts as a mediator and a Chapter 7 trustee in the Bankruptcy Court. Andy, welcome back to Law You Should Know. You've been involved in bankruptcy for a very long time, and it's good you also are involved in mediation and acting as a trustee. We'll learn more about those things in a few minutes. But how has the availability of bankruptcy and bankruptcy filings been affected by COVID?
COVID has had a tremendous effect on the filing of bankruptcies, and it's a little bit counterintuitive because people would have thought that with COVID and people losing jobs and things like that, that there would be more bankruptcy filings. But in fact, bankruptcy filings have gone down significantly from pre-COVID to current times. And
why do you think that is, that they've gone down?
A lot of the reasons are attributable to the fact that the government gave a lot of people stimulus payment. People were getting PPP money. They were getting economic disaster loans. The courts were closed, so people who previously were subject to foreclosure actions or evictions, everything was stopped. So there was really no pressing incentive for people to file bankruptcy.
And a lot of that has ended or will end shortly. So do you think that will generate bankruptcy filings and as foreclosure and collection matters pick up?
That's what we all thought. As time went by, these moratoriums kept on being extended. But earlier this year, the foreclosure and eviction moratoriums ended. Yet we're finding that bankruptcy filings are still decreasing from year to year. In particular, Chapter 7 filings. Just very quickly, I did some research this afternoon. Between January and March of 2021, there were 517 Chapter 7s, let's say. The same period for 2022, it's only 385. I actually had expected bankruptcy filings to pick up for Chapter 7. They've gone down.
And just for our listeners, just explain the difference between Chapter 7 and Chapter 11.
So a Chapter 7 is what we call a straight liquidation. That's where people put themselves before the court and they say, Judge, I'm willing to make available all of my property except that which the government allows me to keep in return for getting a discharge of those debts which are allowed to be discharged. That's a Chapter 7, and we call that a fresh start. And a person will usually get a discharge within a relatively short period of time. Chapter 13 is what we call a reorganization. It's a debt adjustment plan, and that's where people, for various other reasons, are going to be coming up with a plan to pay creditors over a period of 3 to 5 years.
And does that include if someone had a house and wanted to try to stay in that house?
Historically, Chapter 13 is what was utilized by people who fell behind on their mortgage, where the bank was unwilling to give them a forbearance agreement. Chapter 13 forces the forbearance on the bank, allows people to pay back money over time.
And is that a possibility as people emerge from COVID?
Actually, when I was mentioning the statistics, the Chapter 13 filings have gone up. And that may be attributable to the fact that the moratorium is over with regard to foreclosures. And by filing a Chapter 13, there can be an automatic stay. And again, people given some opportunity to propose a plan or to do a modification of their loan with the lender.
And if rates may have started to go back up, but if the rates are lower now, can they refinance theoretically at a lower rate that might be more affordable to them?
That's always a possibility. There's no reason for them to not seek to try and do that, but economically, they just may not be in a position to do that.
With Chapter 13, they'd have to meet the requirements of the plan to pay that monthly nut.
That's right. So basically, in the Chapter 13, you have to show that you have sufficient income to pay your expenses going forward, your mortgage, the food to put on the table for your family, clothing, things like that. And you have to be able to cure the arrears on your mortgage over a period of no longer than 60 months. So whatever the arrears are, you have to divide that by 60. You come up with a number. So you have to be able to afford that payment in addition to paying your current mortgage payments.
Is there a possibility of negotiating some of the debts down, as there might be on the Chapter 7, some of the creditors may take a hit because there's fewer assets available. Does that same logic apply to Chapter 13? Because if the alternative, you can't make 13, it's going to become 7, they may be left with less?
Well, it's not actually a negotiation in a Chapter 7 or a 13. Certainly outside of a bankruptcy, people can contact their creditors and try and do what's called a debt settlement to get them to agree to take less money or whatever is owed over some period of time. That's all between the creditor and the debtor. In a Chapter 13 or Chapter 7, there are criteria basically that says whatever monies or property that you have that's not exempt, that's what's going to wind up going to creditors. Or whatever disposable income you have in a Chapter 13, that has to go to creditors.
Can it be pre-structured in those settings as it might be in a commercial setting where a company is loaded with debt and they work out a bailout?
Well, now if we talk about corporations, that's a little bit different. That wouldn't be a Chapter 13. That would be what's called a Chapter 11 reorganization. Chapter 13 is not available for businesses. So yes, to your question, in a Chapter 11, there could be what's called a prepackaged Chapter 11, where there's been communication with the creditors and they've unofficially agreed to take a certain amount of money. And there are situations, and this usually happens with larger companies, they may hit, the pavement on day one when they file their bankruptcy, and they're filing the bankruptcy and they're also filing their plan at the same time because they want to rush things through the bankruptcy and not have terrible disruption with all the other things that bankruptcy can cause.
If a business or consumer comes to you and they're thinking about bankruptcy, they feel they're in a little over their heads, but maybe they can't tread water and right themselves. Is that something that you'll counsel them to see whether bankruptcy is their best option or perhaps there are other options?
Yes, there are a lot of different triggers where people should say to themselves, I should be talking to somebody, such as they're getting the dunning letters, they're concerned about losing their home, they've run out of the debt limits on their credit card. So if they come to me, we can discuss what the benefits of bankruptcy are. We can talk about the debt settlement that I mentioned to you before. We can talk about what assets are exempt. There's certain planning that could be done. And so we tailor the advice to whatever the factual situation is for the client.
And the debt settlement might be a way of negotiating or restructuring some of the debts without actually filing a bankruptcy?
That's right. Now, debt settlement can be a little difficult depending on how many creditors somebody has, because if you settle with some but not enough of them, you still may be facing a situation where someone's going to get a judgment and take your assets. But if you can negotiate with those creditors and get them to agree to take X number of dollars where they're not going to sue, that certainly is an option. However, there's a cost to that. And what I found is that the difficulty with doing debt settlement is the creditor usually would settle the case for a big discount on what's owed, but they want like money, a lump sum money up front. And so the problem is, to save money, you need money. The way that usually works is people are borrowing money from somebody else in order to make that work, or they might be doing the equivalent of a Chapter 13 plan where they're paying money out over time, monthly payments. But if you utilize one of these lawyers or businesses that do debt settlement, they usually will charge 33% or more of the amount of money that they save you.
This is a debt settlement firm, but I'm saying, do you provide legal services that will help accomplish that maybe for less money? Or is that the province of the debt settlement company? We
do it on occasion, but the problem with our office doing it is that we're not geared with enough people to be making those phone calls, and at attorney rates, it could wind up becoming too expensive. So if someone came in, they have 15 cards, 10 cards, which may not be uncommon.
So someone could do that on their own theoretically, and maybe they could borrow money on their house. Maybe they could borrow money from a relative and offer them 50 cents on the dollar, so they say, or whatever, to get rid of the debt and to get rid of some of this excess debt. And some people suggest that if you're going to buy a house, you want to do that. You don't want to owe too much money.
Absolutely. That's the first thing that I tell people. You don't need a tremendous skill set in order to do these negotiations. And I tell people oftentimes what it is that they have to do. Unfortunately, a lot of people, because it's their own situation, they just have a hard time dealing with it.
I'd just like to remind our listeners that we're talking with Andy Thaler. He's a boutique bankruptcy attorney, and he also acts as a mediator and a Chapter 7 trustee for the Bankruptcy Court. You've told us a little bit about bankruptcy and some of the options, and I just want to remind our listeners, you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. Let's just focus on another aspect of your practice. You act as a Chapter 7 trustee, a position of honor and responsibility by the court. What exactly do you do as a Chapter 7 trustee?
So as a Chapter 7 trustee, my duty is to examine the debtor, also review what's called a bankruptcy petitioning schedules, where assets and liabilities are listed, and to see if there are assets that can be liquidated in order to make payment to unsecured creditors. So if someone has a non-exempt asset, I will sell that asset, and then I will use that money to pay creditors. Or if there is litigation to pursue, oftentimes people that file bankruptcy, for instance, might have a personal injury action that they're pursuing. I become the plaintiff as the trustee, and I administer that particular asset.
And you mentioned exempt debts. A person can discharge many debts in bankruptcy, but there are some they may not be able to discharge. What might some of those be?
Debts that are not dischargeable are things that for public policy reasons the government has determined should not be discharged. So, for instance, if you defraud somebody in procuring a loan, the creditor can come in and establish that, and that debt would not be discharged. If you owe money to a non-moneyed spouse, marital situations, domestic support obligations, so alimony, maintenance, child support are not dischargeable in bankruptcy. Criminal restitution, fines, penalties, the types of things that you can imagine that the government wouldn't want people to be able to just say, I'm filing bankruptcy, and these debts won't get paid. Student loans are not dischargeable for the most part. Very difficult to do.
But there might be some exceptions to that, but generally they're not dischargeable. And you also, on the flip side, if you don't list something on your bankruptcy schedule, it's probably not going to be dischargeable.
If you don't list something and it's found to be purposeful, you could wind up losing your entire discharge. If something wasn't listed, it's also possible that may not be discharged.
And I think there was a recent case of a lawyer who filed bankruptcy and didn't want a debt listed, and that got them into trouble professionally.
Certainly could be a situation.
You also act as a mediator. So you're you help people in many different ways, people and businesses in many different ways. How do you, what kind of cases do you preside over as a mediator?
Well, certainly I handle disputes in bankruptcy court. So I've mediated situations where a trustee was suing people to recover either fraudulent conveyances or preferences. I get involved as being a mediator where somebody might be objecting to an individual's discharge. That's from the bankruptcy end, and it could be any number of different issues that might come up in bankruptcy. And I'm also a commercial mediator with the Nassau County Bar Association panels and with the commercial division of the Supreme Court, Nassau County. And there might be a partnership disputes between a company and vendors. And that's really pretty much across the board. Anything that you might see, a litigation in the commercial part are matters that I would handle.
And when you're acting as a mediator for the bankruptcy court, you don't represent any of the parties, but you're trying to bring them together, understand their different concerns and issues and strategy, and just seeing if with you as a sounding board, you can help resolve their disputes.
That's right. As a mediator, I'm not a judge. I'm a neutral. I'm not deciding anything. I'm nothing more than a facilitator. There are confidentiality. Somebody tells me something, not to be shared with the other side. It won't be shared with the other side. My role is just to get the parties themselves to reach their own agreement, which can be something completely different from what the courts might ultimately decide. They can come up with their own arrangement, which the law does not allow. So it gives an opportunity for a win-win situation for both sides. And
you might be able, with your background in bankruptcy and your knowledge and respect in the bankruptcy community, you might be able to come up with some different options where they can have a meeting in the minds and resolve those issues.
That's right. Sometimes as you get further into the mediation process, the parties might say, what would you, Mr. Thaler, Andy, recommend as a possible settlement? I was also involved with a large Ponzi scheme here on Long Island some years ago, and a lot of people were sued, and they did not have lawyers. And in most of those cases, the cases were resolved. These were clawback actions, similar to the Madoff action, and they really didn't understand the law and what was happening and why, these monies that they received, they thought they were entitled to, had to be given back. And they were settled based on me explaining the law to them.
And this way it can be resolved without worrying about what a court might decide and appeals and attorney expenses. Once you help someone resolve it through mediation, it's resolved.
That's right. There's a tremendous savings in legal fees, and proceedings go a lot faster. People wind up getting what's called discovery a lot sooner. And unlike litigation, where very often the clients sort of hide behind their attorneys, or certainly when they're in court, the attorneys are the ones that are speaking unless someone's called as a witness. In a mediation, people get to talk to one another, or they get to talk to me directly. They get to vent. They can talk about anything that they want, even things that might be hearsay in court or things that may not necessarily be legally relevant, but certainly may be relevant to the parties resolving their dispute.
And of course, while the case is pending or claims are pending, those assets are being used up by attorneys for various parties. There may be nothing left for the innocent people holding claims.
That's right. And so very often what happens is a lot of times cases resolve just shortly before trial because people realize they've spent a certain amount of money already, and now they're going to wind up spending even a lot more money, and they're at risk. The beauty about mediation is you come to a resolution. You've eliminated risk. You know exactly where you stand.
And also because you're versed in the bankruptcy process, if you're representing a debtor or creditor, you can bring those same skills to bear and just, talk to the other sides. Let's get realistic and try to come up with a win-win situation to, help everyone resolve this.
That's true. And even from the perspective of, let's say there's a lawyer that's having difficulty with their client because the client just has unrealistic expectations, I also can, when asked to, serve as a facilitator between even the lawyer and their client to reality test the situation for the client so they know whatever their lawyer is telling them actually is correct and why they should settle or what the weaknesses might be in their case.
And they may think they're going to get a pot of gold or they're going to have $1 million claim at the end of it, but those things may not be possible.
That's right.
Are there other pros or cons of bankruptcy?
Well, the pro of bankruptcy is in the right circumstance, the people can get a fresh start and be relieved of all these debts. One of the cons is if you file a bankruptcy petition, Chapter 7, your credit score is going to go down, but I tell people your credit score might be and probably is artificially inflated if you've just been making minimum payments and now you no longer even have the ability to make minimum payments anymore. So the benefit is that you get the fresh start and then you can resurrect your credit score after you file and you receive your discharge, because then you become a better credit risk for whatever credit that you may be seeking.
And do some people have to put themselves in jeopardy individually if they personally guarantee, let's say, some kind of lease or contract or commercial agreement? So in addition to the business being at risk, they personally and all their assets are at risk, and that might have to lead them to consider bankruptcy?
Right. We always consider that when we meet with people. We find out what obligations they might be personally obligated on, such as guarantees, like you mentioned, co-signed obligations, or fiduciary obligations like sales and withholding taxes.
So just explain the sales and withholding taxes part of it.
So if you're a business owner, basically the government deputizes you as an officer or somebody that handles the money to be responsible for remitting sales tax that you collect from the public and the withholding taxes that you withhold from the pay of your employees. So if you go into those funds, you're breaching a fiduciary duty, and that's one of the grounds for discharge not to be granted if you breach a fiduciary duty.
The entire plan, not just a small part of it.
Say that again.
No, would you be able to discharge all the obligations? That would keep you from discharging any obligation of business, or just those obligations?
Those obligations. Okay. If you had other obligations, if you had a guarantee to a vendor and there was no fraud involved or some other basis to object to discharge, that guarantee could be discharged. But in the same case, you might have a situation with sales and withholding taxes.
But you'd have to file personal bankruptcy to get rid of the guarantee.
That's right. So if you're asking, because some people ask, well, if the corporation files and the corporation is no longer responsible for for that debt, why should I personally be responsible? The individual would still be responsible.
And the creditor won't care if the corporation files because they can hold you liable.
That's right.
So the moral of the story is be very careful before giving a personal guarantee.
Right.
Or co-signing a loan for someone else.
Avoid it as best you can, but unfortunately for small businesses, a lot of times it's a requirement, including SBA loans require, for the most part, that the principal, sign off on the mortgage.
But just be aware that it can affect you personally.
Yes.
I'd like to remind our listeners that we're talking with Andrew Thaler. He is a bankruptcy attorney and has a boutique bankruptcy firm. He also acts as a mediator and a Chapter 7 trustee. What are some other attitudes of the parties or attorneys that help your mediations to be more successful? What are good attitudes versus bad attitudes to help resolve things through mediation in the commercial field?
Well, one of the things that's a struggle for mediators is attorneys who do litigation, and some of them look at it as, well, if I mediate the case is going to be over, and I'm not going to be generating fees, and that's really the wrong thought process in my view, because what you want to do is what's right for the client, and even though people don't go into mediation without preparing. It's just a different type of preparation. You're preparing in order to reach a resolution. The attorney still is going to make fees. They have to be prepared, but they have to know how mediation works. And I'm involved with the Bar Association and the ADR committee, trying to educate the bar and the public exactly how mediation works and the benefits of mediation.
And it's important, as we're talking here today, for clients to be aware of it, whether they're personal or business owners or corporate executives. Mediation can help them lower and avoid their attorney fees. And there may be a possibility of winning a case, but there's always a possibility of one or both sides being unhappy with the result of litigation.
That's right. And now we recommend, if people are entering into contracts and agreements, they should provide a provision in there that the first thing that would take place before litigation is that the parties have to go mandatorily to a mediation. The mediation may not work. People may decide after the first session that they don't want to continue with it. But that really is the way to go. And actually the courts here in Nassau County have, and I'm sure you know this, presumptive mediation. They're sending more cases now out initially to mediation because the courts are so backed up, and they realize now after years that mediation really has a very prominent role in resolving dispute.
And it also has a positive role, and it also is the only situation that can lead to a win-win situation, because when there's a case goes to trial, a judge's decision or a jury verdict, there's usually a winner and a loser, and sometimes both sides are not happy with the result. So with your help in a mediation, both sides can be winners.
That's right. It can be a win-win, but I will say the best mediation is where both sides walk away a little bit unhappy.
Yes, maybe one side didn't get what they want, and one side didn't, gave more than they wanted, but they've saved legal fees, they've saved time, they've saved uncertainty, and they can move on to other more pressing issues.
That's what we find. People don't like to give things up, but in a mediation, both sides may be giving something up. But at the end of the day, now they can focus on their business. Now they're not spending money on attorneys and litigation costs. And the further are they away from the day that they settled the case, the more happy they are. And
they're not spending money on appeals, because one side may win in court at the trial court, and it may be short-lived because a year or two later it may get overturned by an appellate court.
Absolutely.
And you don't know when it's going to end, but there's the uncertainty and the drain on the legal fees on both sides. Andy, any other final thoughts about why mediation is a good thing and it can even help in a bankruptcy situation?
I think we've covered it, in particular in bankruptcy. In a lot of the situations, we're talking also about diminished dollars, because in bankruptcy, it's pretty rare, but it happens where there's going to be 100% distribution to creditors. So if there's a dispute with regard to what somebody is going to receive, it's a little bit easier to resolve things through mediation because in bankruptcy in general, even before mediation became as prominent as it is now, a lot of matters are settled in bankruptcy court. It's just the nature of the beast.
And just give us your contact information in case a lawyer out there or a consumer or litigant wants to contact you.
Sure. My firm is Thaler Law Firm, located at 675 Old Country Road in Westbury. Phone number is 516-279-6700, and the email is athaler@athalerlaw.com, which is also athalerlaw.com is the website.
And what kind of information will someone find on the website?
I write articles from time to time, both some which are geared towards consumers, which is easy reading, also some that are geared to lawyers. They may be looking at the website, so issues with regard to what debts are discharged, what exemptions are, changes in the law, those are all on the website.
And these are information and analysis that's going to be very helpful to lawyers out there and maybe people who are involved in this legal field.
That's right.
Do you have advice for attorneys who are guiding their businesses and why the attorneys should have their clients consider mediation?
I think we covered a lot of it. Mediation should be considered because it can save legal fees and all the trial costs and resolve
the client is going to be happier with them as an attorney because in the long run they save them time and uncertainty.
Right. The issue really becomes down to a lot of times, most times the client goes to a lawyer and they expect the lawyer to be a zealous advocate for them, and the lawyers oftentimes feel a little sheepish about saying, hey, how about if I go to the other side and say, we want to sit down and we want to have a mediation and settle this. Some lawyers look at that as a sign of weakness and not have to have that type of stance with their client.
And at the mediation, that lawyer can be a zealous advocate, but the goal is to try to resolve the matter without any blood.
Absolutely. When they go in, they're going to say, these are all the reasons why we think that we're right. And, they're not really playing to me because I'm not making a decision. They're playing to the other side. So they're both playing to each side. And then when I meet with them in private, we can talk realistically about how strong their case really is, how strong, are the strengths of the other side's case.
Okay, I'd like to thank our guest, Andrew Thaler, for being on Law You Should Know and talking about mediation and the bankruptcy field after COVID. You've been listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College. If you missed any portion of the show, a podcast is available at nccradio.org, and please tune in to Law You Should Know at this same time next week on 90.3 WHPC.